everybody, this is Tracy here with another edition of A View from Tracy's Point. So we're here to talk about the motion that Steve Greenberg filed today to have the Rico charges in the New York indictment dismissed, stating that R. Kelly could not be a enterprise. And I've been asking this question all along, like, how do you have a Rico case with only one defendant? And people, have tried to defend that decision, but I always go back to, I've mentioned to you guys in previous videos that my ex, my two oldest daughters' father, is actually serving prison time from now on the Rico case. And when I tell you about, how the whole federal government situation is set up, when he first went in, when he was first arrested, he had like 30 some odd charges against him. But by the time he went to trial and was eventually found guilty, he was down to like 12 charges were still, sticking to the indictment. But the most serious charges were for murder. And if he had been found guilty on the murder charges, he would have been facing the death penalty, because it was part of the new rule that I believe it was under Bill Clinton, where it said that if you were found guilty in a Rico case and somebody died in the progress of your crime, then you could face the death penalty. And so he was facing these death penalty cases, and they were saying that he had ordered hits on people, but that was all thrown out before the case even started, and then some other charges were thrown out. But when he was arrested, there were several other people that were indicted with him that created the Rico. They were like the people that were out there, allegedly selling the drugs and all of this other stuff. And so all of the people that were indicted with him, either their indictments fell through and they were free to go, or they pled guilty and did not have a trial. They pled guilty, didn't have to go on trial. None of them testified against him. Everybody refused to testify. They just said, give me my 5 years, my 6 years, whatever it is that I'm facing. And actually his nephew pled guilty to his charges, or he might have I think his nephew did go on trial for what he was charged with, and he was sentenced to like 31 years in prison. And then 6 years into his sentence, his case was overturned and he was free to go. So he's out living his best life, married, with kids and all of that. So, you can't just say, oh, because the feds are bringing these charges against you, that they have an airtight case and you should just plead guilty, or you should, in their cases, they accepted the pleas because they weren't facing that much time. And I'm sure if they had been facing 20, 30 years, possible life in prison, it may have been a different story. But for what they were charging them with, the time wasn't that significant, and so they just pled guilty. And it's sort of like what people are saying about the R. Kelly case, like it serves him no purpose to plead guilty to any of these charges or to try and seek a plea deal, because of the maximum penalty on the harshest crime that he's facing. He would still get that amount of years. And so that's looking at it in terms of sentences running concurrent with each other. And so like with my kid's dad, he received like 4 sentences that were 20 years. Okay. He's been in prison more than 20 years. I think he's been in prison like 27 years now. And so if he was only facing those charges, then he would be out now. But then they threw on multiple life sentences for the other few crimes that they did find him guilty of. So he's facing life in prison. And I swear every time I turn around, he done filed some kind of appeal trying to get out. But anyway, that's just an example of how the feds work. And, should you take a plea deal? Shouldn't you take a plea deal? And can you have a Rico case with only one defendant. And I still say that you can't, the only way that can happen is if, in his case, they arrested all these people along with him. And so that established the Rico case. And then those people didn't have to testify against him. They were found guilty, or they pled guilty to whatever their charges were. So yeah, you have a Rico case, but they couldn't go in like they're doing with R. Kelly, where they claim to have interviewed all these people who were a part of the organization, giving these people immunity to testify against him, and then leave him as the sole person sitting up there as the Rico case. And so I'm going to read the motion to you guys. But one other thing I wanted to clear up was, in the last video that I did where I read the indictment, the superseding indictment that came down from the Illinois case, and there was somebody in the chat and we got into a discussion about the victims. And so I don't know if it was a man or a woman based on their YouTube handle, but they were saying that the Jane Doe number 2 and Jane Doe number 3 are not related to the Illinois case. And I was pointing out that according to the New York people, that they are a part of it. And so they were supposed to send me something that they have, but I never did get it. But I did go back and research the motions and the indictments and everything and what was being said. And so I think where I got confused is I believe that the person who was previously Jane Doe number 1 in the New York indictment has since been moved down to number 2, I believe it is, because of the Aaliyah charge that was added to the indictment. So Jane Doe, the current Jane Doe number 2, I believe is minor number 4 in the Illinois indictment. So the other person, the Jane Doe number 3 on the New York case, of course, is a person that was over the age of 18. And so all of the people in the Illinois indictment were all minors at the time. But if you go back and compare Jane Doe number 2 in the New York indictment and minor number 4 in the Illinois indictment, they appear to be the same person. The crime allegedly happened in 1999, and the person was 16 years old. And so that was the confusion in that. And so I think that's what they were taught, the prosecutors were saying when they were saying that it was the same person in the Illinois case. Now, let's go on to this. I believe that was the only housekeeping that I had to go through. Okay, so let's go ahead and look at the motion that Steve Greenberg filed. Okay, and so this was filed on today. And it says, Defendant's motion to dismiss count 1 of the superseding indictment. Defendant Robert Kelly, by and through his attorneys, respectfully moves this court, pursuant to Federal Rule of Criminal Procedure 12B3, capital B, Roman numeral 3, and Roman numeral 5, to dismiss count 1 of the superseding indictment. In support of this motion, Defendant shows the court the following. And then I did look up that procedure because someone has said to me, you read all those numbers and codes and everything, but you never tell us what they are. And so for the most part, they're court cases that they're citing as case study to support their motion. But in this case, they're actually referring to a code. And so I'm going to go ahead and read to you guys what that code is. Okay, and so it says Rule 12, Pleadings and Pretrial Motions, primary tabs. Then B that they mentioned is pretrial motions. Then the number 3 is motions that must be made before trial. The following defenses, objections, and requests must be raised by pretrial motion if the basis for the motion is then reasonably available and the motion can be determined without a trial on the merits. And then the capital letter B is a defendant in the indictment or information, including, and then Roman numeral 3 is lack of specificity, and then Roman numeral 5 is failure to state an offense. And so those are the grounds that they're basing this motion on. Okay, and then Roman numeral 1, summary of the charges. Defendant is charged with 1 count of violating section 1962C of the federal Rico statute relating to 6 victims, Jane Doe's numbers 1 through 6, and 4 substantive counts of violating the Mann Act, all of which involve only Jane Doe number 6. Now, Jane Doe number 6 is Faith Rogers, and we all thought that it was Azriel, which is Jane Doe number 5, but they're saying that all of the Mann Act, it says 4 substantive counts of violating the Mann Act, all of which involve only Jane Doe number 6. And then it says, with respect to the Rico count, which was clearly alleged as an end run around the applicable statute of limitations for the underlying predicate acts, the superseding indictment alleges that the purported Rico enterprise was an, quote, association in fact that was comprised of Defendant Kelly and unnamed members of his entourage, including managers, bodyguards, and personal assistants. The superseding indictment reads, the enterprise, 1, the defendant Robert Sylvester Kelly, also known as, quote, R. Kelly, and individuals who served as managers, bodyguards, drivers, personal assistants, and runners for Kelly, as well as members of Kelly's entourage, comprised an enterprise, and it has in parentheses the enterprise, within the meaning of 18 United States Code 1961, parentheses 4, that is, the enterprise constituted a group of individuals associated, in fact, that was engaged in and in the activities of which affected interstate and foreign commerce. The enterprise constituted an ongoing organization whose members functioned as a continuing unit for a common purpose of achieving the objectives of the enterprise. So that's what the original indictment stated, and they're just pulling that part out to support their claim. And so it says superseding indictment at paragraph 1, the alleged purpose of the Rico enterprise was to, quote, promote Kelly's music and the R. Kelly brand, in parentheses, which is not a crime, and, quote, to recruit women and girls to engage in illegal sexual activity with Kelly. And it has ID at paragraph 2. The alleged predicate acts purportedly occurred sporadically between 1994 and 2017, the majority of which bear little connection to the Eastern District of New York. Then it has a note at the bottom where they then they have a note at the bottom where they reference some information. And so for that reference, it says, given the extremely liberal venue standards in criminal prosecutions that United States Code 183237A, and given that some minimal part of the criminal activity is allegedly to have occurred in the Eastern District, venue may be proper in the district. See example, United States versus Long, 697F, supposition 651655 through 56, Southern District of New York, 1988. And I actually looked up that case, and I believe this is the case about the Teamsters Union and some corrupt stuff that they were doing. But once again, when they're citing these cases, these are cases that were actually overturned or what have you, in support of what they're trying to get done here. So it says, that said, the defendant is from Chicago. The majority of the alleged wrongs occurred in the Northern District of Illinois, and pending charges exist in the Northern District of Illinois, charging defendant in a separate indictment in an out-of-state district. It's basically, they're saying is rather than superseding the existing Illinois indictment is unfair, inconsistent with the norm, and seemingly calculated to make it more difficult to defend against because it says, inter alia, as the government is aware, Mr. Kelly has very limited resources. So he's basically saying by them doubling up on these charges in Eastern District of New York, as well as the Northern District of Illinois, is basically unfair, and they're basically trying to break him down because he doesn't have the financial resources to defend both of the cases. And then let me see what this inter alia means. Alia. Okay, so that means among other things. Okay, so let's remember that. And let's go back here. And so it goes on to outline, it says number 1, 1994, Northern District of Illinois, Jane Doe number 1. 1999, Northern District of Illinois, Jane Doe number 2. 3 through 4, 2003 to 2004, Northern District, Illinois, Jane Doe number 3. 5 through 7, 2009 through 2010, Northern District of Illinois, Jane Doe number 4. And then 8 through 9, 2015, District of Connecticut and Northern District of California, Jane Doe number 5, and 10 through 12, and counts 2 through 4, 2017, Eastern District of New York and Central District of California, Jane Doe number 6. And so they're basically showing you where the specific crimes are alleged to have occurred. And so they're pointing out that in the Northern District of Illinois is where Jane Doe 1, 2, 3, and 4 cases originated. And so they should be a part of the Northern District of Illinois case. So it says predicate acts 2 through 12 all relate to defendant allegedly coercing women and girls to engage in sexual activity with him. Act 1 is an outlier and accuses Mr. Kelly of bribing a government official to produce a piece of fake identification for Jane Doe number 1. No other charges related to Jane Doe number 1 and the superseding indictment is silent on how that predicate act fits into the overall purpose of the enterprise. And so that's something we talked about before, like you're accusing him of bribing this official to get the fake ID for this marriage that was ultimately annulled, but you're not alleging any kind of sexual activity, underage, any of that. None of that stuff is being alleged in this case, just the fact that he bribed this official to get this fake ID. And so then number 2, applicable legal standard, it says in deciding a motion to dismiss an indictment for failure to state a criminal offense, a court must assume the truth of the allegations in the indictment and determine whether the indictment is valid on its face. United States versus Perk 267, and it gives that case information. It says quotation marks and citations omitted. In deciding a motion to dismiss for failure to state an offense, a court may generally not look beyond the face of the indictment, nor may it draw inferences as to the proof that would be introduced by the government at trial. United States versus Alfonso. Finally, and importantly, when reviewing an indictment for sufficiency, quote, common sense must control, end quote, United States versus Stavrolowski. See also United States versus Torres, noting that a court must review an indictment, quote, as a whole rather than in a hypothetical manner, quotation marks omitted, and then says, that said, an indictment or a portion thereof may be dismissed if it is otherwise defective or subject to a defense that may be decided solely on issues of law. United States versus Labs of Virginia Incorporated. An indictment does not pass muster simply because it parrots the language of the statute, quote, where the definition of an offense includes generic terms, it is not sufficient that the indictment shall charge the offense in the same generic terms as in the definition, but it must state the species and must descend to particulars, and that's United States versus Pirro. Then it goes on and cites another case, and it says, in other words, the allegations in an indictment must, quote, allow a court to evaluate whether the facts alleged could support a conviction. And then it says, the documents for dismissal urged in this motion present pure questions of law that the court can and should resolve before trial. No argument implicates any dispute or fact or requires the court to draw any inference about the truth of the government's allegations. The allegations regarding the, quote, enterprise on the face of the indictment are simply inadequate to meet the legal requirements of a cognizable Rico enterprise in fact, or the government's ability to prove them at trial. Accepting those facts as true and based on the arguments that follow, the court may and should dismiss counts 1. And then part 3, analysis and argument. A, the indictment fails to properly allege a legally cognizable Rico enterprise, so count 1 must be dismissed. The government would like the court to believe that an individual, namely Mr. Kelly, an unnamed, unidentified associate, somehow formed a legally cognizable Rico enterprise for the purpose of federal criminal prosecution in this case. Notably, the superseding indictment is completely silent regarding any acts taken by any other individual aside from Mr. Kelly. As alleged in the indictment, a single person acting in the manner that Mr. Kelly allegedly did does not form a legally cognizable Rico enterprise under the law. As such, count 1 of the superseding indictment is flawed on its face and must be dismissed. The federal Rico statute was designed to prevent the illicit infiltration of legitimate enterprises, SREP number 91-61 at 76, stating that Rico's purpose was the elimination of the infiltration of organized crime and racketeering into legitimate organizations operating in interstate commerce. This explains why the conduct prohibited in Code 1962 is unlawful only if it occurs in connection with the investment in, acquisition of, or operation of an enterprise affecting interstate commerce. In other words, Rico generally does not target the enterprise, but the bad actors who misuse or wrongfully acquire or invest in a legitimate enterprise. United States versus Turkey, 452 U.S. 576 591, and that was in 1981. Section 1961, Section 4 defines an enterprise as any individual, partnership, corporation, association, or other legal entity, and any union or group of individuals associated in fact, although not a legal entity. Any group of entities or individuals that is associated in fact may be a Rico enterprise. United States versus Philip Morris, USA, Inc. However, many courts require the association in fact enterprise to have some structure of hierarchy and an ongoing legitimate purpose that was different from a group that is joined solely to violate Rico. And then it says C, United States versus Bledsoe, and it gives the case information. And then it says, we are satisfied that Rico was not designed to serve as a recidivist statute, imposing heavier sentences for crimes which are already punishable under other statutes. The act was not, The act was not intended to be a catch-all, reaching all concerted action of two or more criminals involving two or more of the designated crimes. In 2009, the Supreme Court further addressed whether an association, in fact, enterprise must possess an ascertainable structure beyond that inherent in the pattern of racketeering activity in which it engages, Boyle versus United States. The Supreme Court held that an association, in fact, enterprise under Rico must have some structure, but relying on both United States versus Turkett and the plain language of the Rico statute, identified only three required structural features: one, a purpose; two, relationships amongst those associated with the enterprise; and three, longevity sufficient to permit those associates to pursue the enterprise's purpose. Here, the superseding indictment fails to meet any of these requirements. First, the common purpose alleged, to promote Kelly's music and the R. Kelly brand, and two, recruit women and girls to engage in illegal sexual activity with Kelly, fails to pass muster. It clearly is not unlawful to promote music or a brand, and the superseding indictment is silent on how any other individual benefited from Mr. Kelly alleging engaging in sexual activity. If no others benefited, then the only member of the enterprise is Mr. Kelly. Second, the superseding indictment fails to allege the relationship amongst any of the members of the enterprise. Indeed, with the exception of Mr. Kelly, the superseding indictment is silent as to the identity of any of the alleged members. This lack of specificity blatantly fails to satisfy the requirements of Federal Rule of Criminal Procedure 12B3B, and then the Roman numeral 3. That's what I read to you guys earlier. And it says, third, given that the indictment names only one individual, there is no way for the court to evaluate the enterprise's longevity. It is inconceivable that the same members existed in both 1994, the first predicate act, and 2017, the last predicate act. And without alleging who the other members are or how they formed the alleged enterprise, neither defendant nor this court can adequately assess the nature of the enterprise or appropriately defend against these charges. Most importantly, in this case, Mr. Kelly is charged specifically with a violation of Section 1962C. See superseding indictment at page 14. Section 1962C prohibits any person employed by or associated with any enterprise from conducting the affairs of that enterprise through a pattern of racketeering. All courts of appeals have concluded that this language means that in Code 1962C case, and it has underlined, a party cannot be both the defendant, person, and the enterprise. See Doyle versus Hasbro Incorporated. Then it gives all the codes and sections, and then it says affirming dismissal of Rico claim where plaintiff failed to identify an enterprise distinct from defendant. And then, child, they go and they give 1, 2, 3, 4, 5, 6, 7, 8, 9, okay, a page, like a full page of all these cases that were thrown out because they tried to pull what they're pulling with R. Kelly and saying that the person can also be the enterprise to construct this Rico case. And then it says, courts generally recognize that the defendant may be a member of a larger association, in fact, enterprise, without violating the person-enterprise distinction, but all have held that the defendant must conduct the enterprise's affairs, not merely his own affairs. United Food and Commercial Workers Union versus Walgreens Company, Riverwoods, Chappaqua Corporation versus Marine Midland Bank. A defendant can only be liable under 1962C if he exercises a managerial role in the enterprise's affairs. Reeves versus Ernst and Young. Here, the government has failed to plausibly allege that Mr. Kelly directed or managed the affairs of an enterprise that is distinct from himself as a person. The superseding indictment does not identify a single person that worked with Mr. Kelly, either by name or pseudonym, nor does it allege that a single action taken in furtherance of the conspiracy was performed by anyone other than Mr. Kelly. Without a difference between the defendant and the enterprise, there could be no violation of Rico. Baker versus IBP Incorporated, dismissing where the enterprise was not adequately specified. Even if the superseding indictment did properly allege these facts, it is clear from the face of the superseding indictment that any alleged enterprise members were Mr. Kelly's employees. Cruz versus FX Direct Dealer LLC, noting that the required person enterprise distinction, quote, cannot be evaded by alleging that a defendant has violated the statute of conducting the enterprise that consists of itself plus all or some of its officers or employees. This indictment simply fails to add an unlawful Rico enterprise. Reading the facts in the light most favorable to the government, it is impossible to distinguish between the defendant and the enterprise itself, so the courts must dismiss count 1 of the indictment. And then for conclusion, Rico was not designed as a means to punish a single individual for his own wrongful acts. As the court can see, substantive offenses were only charged relating to one of the 6 Jane Does. Rico is only being used in this case in an effort to subvert various statutes of limitations. Robert Kelly is not an enterprise. The superseding indictment seems to think otherwise, but the law does not. Accordingly, count 1 must be dismissed. Respectfully submitted, Steve Greenberg. So a lot of technical jargon, but basically the legal way of saying that you cannot have a Rico charge with only one defendant is what it basically boils down to. And then I believe it was the Chicago Times had an article that came out, and basically, let's see what they said. Lawyers for R. Kelly said in a court filing Friday, the federal racketeering charge brought against him in New York is a thinly veiled attempt to circumvent the statute of limitations on sexual misconduct and should be tossed out of court. And so basically, I guess the people that are in the New York indictment exceed the statute of limitations in Chicago, and this is why they created this case. It says the sweeping indictment alleges Kelly and his associates recruited women and girls for illegal contact with the singer, then isolated and threatened them to keep them under control and prevent them from going to authorities. To prove racketeering, prosecutors have to show that Kelly was the leader of a criminal enterprise that included co-conspirators such as managers, bodyguards, drivers, personal assistants, and runners. But according to the motion to dismiss filed Friday, the charges failed to specifically name any co-conspirators, not even by pseudonyms and therefore fall short of the burden needed to bring a racketeering case to trial. Robert Kelly is not an enterprise. Kelly Lee's attorney, Steve Greenberg, wrote in the motion, Rico was not designed as a means to punish a single individual for his own wrongful actions. Rico is only being used in this case as an effort to, bypass the statute of limitations. And that's a quote from the indictment that I just read. The 11-page motion also said the common purpose of the enterprise, as alleged in the indictment, to promote Kelly's music and the R. Kelly brand fails to pass muster. It's not illegal to promote a brand, and the charges are, quote, silent on how any other individual benefited from Mr. Kelly allegedly engaging in sexual activity, end quote. And then it goes on to talk about the different charges that he faces in different jurisdictions. And it talks about if convicted, could spend the rest of his life in prison. U.S. District Judge Harry Weber in Chicago has set a tentative trial date in April. The New York case has been set to go to trial May 18th, but the judge there moved it to July 7th to avoid conflicts. And then a trial in Cook County is currently set for September. Meanwhile, records obtained by the Chicago Tribune indicate prosecutors in New York have been collecting a wide range of evidence regarding Kelly's associates and business interests as part of their case. A subpoena sent last year to the Illinois Secretary of State asked for driver's license photos and vehicle registration history for 13 individuals, including R. Kelly. Among the associates named in the subpoena was Jermaine Bubba Maxey, a Chicago music producer who was publicly accused by Geronda Pace of recruiting her after she attended Kelly's child pornography trial in 2008 when she was 14, according to a copy of the subpoena obtained by the Tribune. And you guys know Bubba is supposed to be, his handle on social media is Ruby Chris, and he was the tattoo artist that Geronda stalked on MySpace. And that's how she connected with him and allegedly got the invitation to the party. But according to her friend, when she got to the party, she was not allowed to get in because she couldn't prove her age. And then I guess she went back and got her fake ID and then went, and came back. And that's how she was able to get in with this fake ID. But they are trying to make it seem like she met R. Kelly at his trial, which we all know she didn't meet him at the trial. She was like running behind him trying to get an autograph or something. And so when that didn't pan out to what she wanted to pan out to, she spent like the next year trying to figure out how she was going to get over there to that mansion and get inside. And so that's who Jermaine Bubba Maxey is. And then it says, Maxey has not been charged with wrongdoing. Pace is one of the alleged victims in the Cook County case. The subpoena also sought records on June Brown and Darren McDavid, which we already know that they have been charged in the Illinois case. And it says as well as several producers and sound engineers who worked with Kelly on some of his biggest hits. In January, prosecutors in New York sent a separate subpoena to the Chicago Department of Buildings requesting documentation of inspections and code violations related to Kelly's former recording studio on North Justine Street. According to a copy supplied to the Tribune through an open records request, prosecutors have said that some of the alleged sexual abuse took place at the studio, which Kelly vacated after he was criminally charged in Cook County last year. And I think you guys heard about the the court hearing in the divorce case where I guess Drea has violated the non-disclosure. Something Drea has said that Steve Greenberg believes will put her in violation of whatever non-disclosure they have in their divorce proceedings. That was supposed to take place, but Drea didn't show up. I haven't been able to find any concrete information, just people making posts on social media, and then bloggers kind of like piecing stories together that really haven't been verified, just taking posts from Twitter and then creating a story out of it. But they're alleging that Drea did not show up in court because she wanted R. Kelly to pay for her flight and for her lawyers and whatever to come and appear in court, which I think is totally crazy. And so the hearing has been postponed, I believe, to May 1st, and Drea has to appear, or I guess she'll be held in contempt of court. And then people were saying that Steve Greenberg told the judge that he didn't understand why R. Kelly had to pay for Drea to come to court, because he didn't pay for her to be in Chicago just 2 weeks ago when she was dropping it like it's hot or twerking on that video that was floating around Twitter. And so I don't know if that's true or not, but allegedly he told the judge that Drea had been in Chicago for the NBA All-Star game, and that he didn't see why she couldn't have appeared or why she needed financial assistance to get her to appear. And what else? And so that's it for me. I just wanted to bring this information. It seemed like there was something else I was going to share with you guys about this indictment, but I didn't make any notes, so obviously it wasn't important, okay? So go ahead and let me know what you guys think. Do you think that this particular motion, I mean, they cited, like I said, a whole page full of cases that, you know, the courts ruled in favor of for dismissing the Rico case as it applies to the information that they've given. And so I don't see any reason why his case would be any different. Or do you think that the New York prosecutors are going to start rounding people up? Okay, because like I said, it's one thing to give people immunity or to give people, you know, a plea deal, but in order to do that, you first have to arrest them and charge them with a crime. You can't just bring people in and say, okay, we're going to give you immunity for your testimony when you haven't even charged them with anything, when they aren't even facing any years in prison. And so I think New York may have shot themselves in the foot with this one, or maybe, you know, like they were hoping, okay, we keep him locked up, he'll break mentally and just cop a plea, or, you know, he'll see all these charges against him and get scared and, you know, back out, you know, or plead to something. Like, I don't know what the New York case is thinking, but evidently they do what they want to do over there in New York. And because as we see, did Harvey Weinstein ever make it to Rikers Island? I think I read a story where they said that the prison officials, well, just to back up, for those of you who may not know, Harvey Weinstein was found guilty on 2 of the lesser charges of, I think he was facing like 5 charges. The 2 charges that carried the least amount of time, he was found guilty on. And actually, I think I was going to talk about this in another video, because one of the jurors was a black chick, looked like she could have been in her late 20s, early 30s. And she did an interview where she was basically saying why she voted the way that she did, why the jury voted the way that they did. And basically it had nothing to do with the law, nothing to do with case law, but it was how they felt. It was their feelings about what he would have done. And so Harvey Weinstein was supposed to be remanded immediately and taken to Rikers Island. But on the way to Rikers Island, they did a U-turn. He was put in an ambulance to go to Rikers. But then something happened. They did a U-turn, took him to Bellevue, which I thought was a mental hospital. But now I don't know if he's been transported to Rikers or not at this point, but I did read a story yesterday where the officials at Rikers Island were saying that they did not want to take on the responsibility of a prisoner that has medical problems, such as Harvey Weinstein. Like, they didn't want that responsibility. And so his sentencing is March 11th. So they were trying to say that, you know, just keep him at Bellevue because it's only like a week and a half, 2 weeks to go. Why go through the trouble of bringing him there, having to go through this extra work to, you know, deal with his health issues. And so while I have you guys here, let me go see what Harvey Weinstein is up to. There's an article from today. It says, Hollywood mogul Harvey Weinstein is in the dumps and doesn't get why the jury convicted him. His spokesperson said he doesn't understand how the jury didn't understand that he's not guilty on any crime, said Judith Engelmeyer, who visited Weinstein Friday at Bellevue Hospital, where he's been held since Monday, when a jury found him guilty of 1 count each of criminal sex act and rape. He's passing the time reading books about Winston Churchill and chatting with his 2 young kids, the spokesman said. So I guess he's still at Bellevue, but this was something that I had said to somebody the other, on Twitter, I think it was. I said, they probably showed up at court on Monday already with the motions prepared in the event that he was found guilty to, 1, have him out on bail until his sentencing, and 2, once he is sentenced, have a motion to have him out on bail while pending his appeal. And so right here, this blurb says Weinstein's legal team hasn't decided whether they'll ask a higher court to grant him bail pending his appeal before his March 11th sentencing. And so we already know that that's in the works because they already said they're going to appeal the decision. And so why not appeal, why not file a motion to have him released on bond? And now they can, cite the fact that he's sick and he's ill and the prisons aren't equipped. So, I mean, it's a setup to keep him out of jail. We're going to see how long the setup work and whether he avoids any significant jail time. I think the minimum he is facing is 5 years. So on 1 count, the maximum I think was 4 years. And then on the other count, it was a minimum 5 years, maximum 20 years. And so so he's basically facing 5 years regardless of what the outcome is. And then this isn't federal court, I don't think. I think this is regular state court. And so here in Florida, for every day you serve, you get a day, and with good behavior, you get a day off. And then they have other calculations. And so I was telling somebody, a person sentenced to 5 years in Florida, if they go in, have good behavior, whatever, they will be out of jail in 18 months, and then they'll probably do like 6 months in a halfway house, and then they will be free to go. And so I don't know if New York is set up the same way, but I don't foresee Harvey Weinstein spending too much time in prison. Hell, him and Bill Cosby might be walking out at the same time. So guys, that's it for me. Let me know what you think. Leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.